Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which is of an area of great interest even now. It's the book is called The Law of Political Donations. Very topical, very emotive issue. Obviously you've got huge arguments in the basic press comments between the big business that run the Tory party and the unions who run the Labour Party, and all these big donors giving lots of money. We never hear about the Liberals, of course, but they get a lot of money as well. And of course you hear from donors for UKIP and so forth. So the question really today is, what is the law at the moment in this particular area? Well, WILDY, SIMMONDS and Hill have produced a first-class book, been written by Michael Smyth, CBE, Patricia, Barratt and Fraser, Campbell. As I say, it's WILDY, SIMMONDS and Hill Publishing. Elizabeth and I gave for our review title the following: an important book for our times as they continue to get the rules wrong deliberately. And there's a certain amount of irony in that title for obvious reasons, because I don't think the heart has been in quite a lot of the proposals that there have been in the past for changes. Let's look at the book first and then we'll tell you a bit about what's in it. There's the front, there's the spine, and then there's quite a lot on the back. If I just pull it back a bit, you can see that there's quite a large amount of information there. Now, it's a hardback, blue cover. It runs to 350 pages, and the index on this occasion is by paragraph numbering, which you've always got to be a little bit careful as to how to find things, because there are a large number of appendices, which we'll get onto in a minute. If you go to the front of the book, you've got, that is the front page there. Then you've got some information about WILDY's and the detail of the book. It was first published actually in 2012, so it's a little while ago now. And we had there's a foreword as well, which has been written by Lord Phillips of Worth Matravers. Then there's the preface by the authors, and then you've got the various contents section. You've got an introduction, and you've got a whole series of chapters looking at things like enforcement. There are a total of 8 chapters looking right at the end, beyond the United Kingdom, the outline of the EU position. Well, I have to say that since this has been written, of course, we've decided to leave, so there will be some changes if the new edition comes out. And there are 9 appendices which are set out there. There's some case law, of course. There are some quite well-known cases that 1 or 2 people may be aware of. Not a large number, but there are a few. Table of statutes, then the statutory instruments and codes of practice, etc. Then table of EC and international legislation, overseas legislation as well, because again there's an overseas dimension to this. Then you've got the introduction, main body copy, and you've got footnoting. And then when you get into the subject matter itself, that's the introduction, which is quite a long one. You then get to the person who is described as the donor in chapter 1. You've got paragraph numbering, and you've got the footnoting. So as I say, you've got a lot of detail. Then there's the parliamentary regime covered in the middle. Now, it's an interesting book, and as I say, the problem with this area is that the issue's been with us a long time, actually, but not a lot has been done about it. This book was written some time ago now. I'm reviewing it because it's quite topical. We've now decided to leave the EU. We've got fixed-term parliaments, so we have a parliamentary session from 2015 to 2020. Whether in fact anything on this particular area of parliamentary activity and the way in which we elect people and the way the parties are organised, whether anything's done about it is another matter because of Brexit. However, I still think the issues are there because the public perceive, or certainly did until Brexit, perceived Labour to be the unions and the Tories to be big business and all the other parties having egomaniacs giving them money. Not that they're all egomaniacs at all, but they're possibly 1 or 2, but they will remain, of course, nameless. Now, what do we say about the book? Because, as I say, I think this is a subject that won't go away, and it'll be interesting to see how it develops in the next few years. Well, we say it's an excellent first edition, and I point that out, of a legal textbook with practical value, basically for all involved in the political process, and I think should be compulsory reading for all candidates and agents, although it's getting a bit out of date now, as I said, because we've had a general election since the book was published. And Lord Phillips, of course, kicks it off by saying in the foreword, this book sets out all the relevant law in a straightforward and thematically coherent way. Yes, it does. He goes on to make some acute observations about the mess in which this law remains, writing that strangely, proceedings concerning the relationship between money and politics have not often troubled the higher courts. Well, I'm not surprised, it costs a lot of money. Phillips concludes that perhaps it's a tribute to the quality of our democracy, he's too kind, or perhaps it's because our system of regulation both in and out of Parliament are really effective, even kinder. But he does suggest there may be other less satisfactory reasons, although the fact remains that our case reports contain surprisingly few judgments about the mechanics of political organisations, despite the complexity and multiplicity of many of the rules, limitations and prohibitions in this area. And that is where the problem lies after the more recent sets of elections, which actually brought us a Conservative majority government to power. This is in 2015. The great thing about the book, though, is that it's in a single volume and cries out for updating on a regular basis, hint, hint, to the publishers. That is on the assumption, of course, that Parliament itself will one day soon produce more robust rules on who can donate politically and what checks take place on rewards, in other words honours, after massive recent criticisms, again, of dubious awards. That includes Cameron's list, and we'll have to see what the next list comes up with. The next one will be the birthday honours list for 2017, and we'll see what happens with that list. But there's always a complaint that some of these people who pay money to parties are given some sort of gong, and people don't like it. We feel then the time is right for reform, but then that's another edition of the book, and we may be leading towards that, because at the moment, the way the honours system operates, the people who are getting honours, the names appear some long time afterwards, so the lists that are currently being looked at are lists dealt with under the previous Prime Minister, Mr Cameron, rather than Mrs May. So that gets her off the hook for the time being. The problem is that we've still got the issue of people being given these awards because they've made donations to a political party. And the question is if that's right or wrong. Well, it isn't. It is wrong, and it's also immoral. But Parliament hasn't done anything about it. So what's in the book then? The publishers, WILDY, SIMMONDS and Hill, describe their work as a clear practical guide to the legal and compliance risks which attach to giving and receiving political donations in the United Kingdom. Of great assistance at the beginning of the title, it explains what a political donation is and sets out the scope of the relevant law, which I found actually very helpful. It's much wider than simply making contributions to party funding, and the amounts, of course, which are that was the criteria brought in at one stage. But of course we are talking here not about small sums of money, we're talking about very large sums of money. Now the authors, as I say, Michael Smyth, I believe it's Smyth, it could be Smith, but Michael Smith, Smyth, or Patricia, Barratt and Fraser, Campbell, and describe who is permitted to be a donor, which is the main chapter 1. And they examine the requirements on companies and when those requirements are triggered. And the powers of the Electoral Commission, of course, are also well covered here, although a new edition I think will certainly be needed to cover major political rows on funding since the book first appeared in around about 2012-13. Obviously that's 5 years on effectively now for me reviewing this book, but I thought it was timely to do so after what happened with the last two sets of honours lists. The writers consider the link between the legislative framework affecting political donations and parliamentary rules on the acceptance of gifts and sponsorship. There's a useful description of how the Bribery Act 2010 will apply to political donations. That, of course, has only just come in when this book had been written. We found a separate chapter gives the reader a fascinating overview for comparative purposes of the relevant international instruments, including the law on political funding in the United States of America and the EU rules, written, of course, before Britain's exit from the European Union. Although the points, I think, are very well made and will subsist. The trouble is we are right in the midst of the Brexit issue, and that's going to dominate public issues and certainly political matters for the foreseeable future, I would have thought. Significant statutes are actually included in the book. That's the Political Parties, Elections and Referendums Act 2000, the Electoral Administration Act 2006, and the Companies Act 2006. That's the giving of money from companies as political donations. And I think they're very well explained. Let me conclude by saying that the three writers have considered the effect of the Political Parties and Elections Act 2009, already now established piece of legislation, the purpose of which, of course, is aimed at ensuring greater transparency. Notice the word transparency here, it was a Labour government, concerning political donations and the reinforcement of arrangements for regulating candidature expenditure. The last matter having raised its ugly head during the 2015 elections, again, some 6 years after that Act of Parliament. But one can see the subject matter is not going to go away. It's on the back burner, I think, as a political agenda item at the moment, but we will wait and see. The law is as stated at the 30th of April 2012. Let's just have a quick look at the book again. There it is, front, spine, and then there's some of the detailed blurb on the back, which I've taken for the review. This is enforcement. Now, this is an area where we may be getting into, this is probably the area that certainly the press are more interested in. This is enforcing something. The law of political donations is principally enforced by the Electoral Commission. And it then goes on again, got the paragraph numbering and the footnoting. But it looks at the way in which an investigation takes place and the various things, the powers, disclosure and so forth. It's an interesting area, but as I say, I found this book fascinating, and it's one that I would think we will hopefully have a further edition of in due course. In the meantime, thank you to WILDY, Simmonds and Hill Publishing, and to the three authors and everybody involved for another excellent publication. Bye-bye.